Hey Simpson, I'm coming to see you, bro. You violated my constitutional rights. I am coming to see you, bro.
Hey, I hope you are not making a threat against me, because that's going to cause you a whole bunch of other problems.
National. I'm appearing sui juris. You is not my attorney. That's not working for me. We got a whole issue. My all my constitutional rights have been violated. I want it on the record. I was arrested by a lie. I want it on the
Okay,
record.
first of all, I'm going to stop this. I directed this defendant to be in this courthouse in person.
I got a bad back, sir.
And he is not here in person.
Sir,
I am not going to sit here and listen to him ramble on and on about everything.
Oh, really?
I don't mind hearing from people, but I tell you, if you're going to say it all, you're going to say it to my face. Bench warrant will issue for defendant's failure to appear. No bond.
I am here.
We'll get him here.
I got a medical issue.
You can mute him. Thank you, Mr. Kilowald.
Buckle up, guys. Today we're jumping straight into a courtroom that goes from zero to chaos instantly. The defendant opens by accusing the judge of violating constitutional rights and escalates it into what sounds dangerously close to a threat. The judge doesn't entertain the rant for a second, shuts it down hard, and makes it clear that Zoom bravado won't be tolerated. This opening sets the tone fast: authority versus unchecked defiance, and the court is not in the mood.
Okay, Judge. Thank you. Judge, if I may say, he does have some medical issues. That being said, all I wanted to do was set it for exam.
Well, when he gets here and graces our doorstep, I'll be more than happy to set it.
All right, I'll bring my constitutional book. Thank you, Your Honor. Thank you.
All right, thank you, Mr. Phillips. Court does call the case. People versus Gary Coward.
Good afternoon,
I
Your
know
Honor.
this. Hey Simpson, I'm coming to see you, bro. You violated my constitutional rights. I am coming to see you, bro.
Hey, I hope you are not making a threat against me, because that's going to cause you a whole bunch of other problems. Yeah, I bet you it did log out. Get that number. It will have the full number. We'll go find him. Get the detective bureau on that, please. All right, let's go.
Here, the judge pivots from words to consequences. The defendant was ordered to appear in person and didn't, which immediately triggers discussion of a bench warrant. You can feel the tension rise as the court talks about locating him, involving detectives, and physically bringing him in. This is the moment viewers realize this isn't just talk. Failure to follow court orders has real, immediate fallout.
You don't want to come up here now, do you? I know. He's just standing there like, man, I just call my name. I'm just up
Do
here.
you want me to contact the Detective Bureau for your job?
Pardon?
Do you reach out to the DB?
I think he is.
Okay. Got it.
Your name, sir?
Gary Coward.
And who's representing Mr. Coward? Mr. Burgess?
I am. Sorry, Your Honor. Good morning. Good afternoon. May it please the Honorable Court, David Burgess on behalf of Gary Coward. I'm appearing via Zoom, Judge, because it seems a little scary in your courtroom today. So.
Wow. I'm calm.
My client is present, Your Honor. He's raising no constitutional issues, and he is a citizen of the United States.
Yes.
Trevor Maysville. Stephanie Can on behalf of Mr. Wilson. Mr. Wilson, could you please state your name for the record?
The courtroom resets as a new case is called, but the tension doesn't disappear. Defense counsel appears via Zoom and awkwardly jokes about the courtroom feeling scary, which lands poorly given what just happened. This segment shows the sharp contrast between casual lawyering and the seriousness of the situation, keeping the audience engaged while the court regains procedural footing.
Ralph Wilson. What will we do?
Your Honor, we are asking for a brief adjournment in this matter for see if we can get any negotiations going. In addition to that, because of how his phone accepts incoming calls, we were not able to act yesterday. So the first time I've had the opportunity to speak with him is, or not yesterday, Tuesday. The first time I've had the opportunity to speak with him is today.
All right. Before I give you your date, there's a violation report. Have you seen it?
No, Your Honor. May I approach?
It's a scram tamper.
May I approach? So, Your Honor, in speaking with my client, he has indicated he is not drinking. He has not been drinking. The only thing he can think is happening is that his job and what you do for a living.
Custodian. I'm on diabetic. I mean, I'm on disability, but I work for First United Methodist Church downtown Ipsy behind the transit. And I work with a whole lot of chemical. I mean, I wash my hand, but I do use hand sanitizer.
Now, the focus shifts to a scram bracelet violation, and this is where the real legal dispute begins. The violation report is introduced, and the defense claims the defendant hasn't been drinking at all. You can hear the skepticism immediately. This moment lays the groundwork for everything that follows, framing the central question: mistake, excuse, or violation.
But when I got the ankle bracelet on November the 10th, the lady put it on, but she put it on this one on my right leg too tight. So when I got out the next day, I went over there and they took it off my right leg and put it on here, but it's on my bone. And so the only thing I did, no one tell me anything. So I just took a piece of tissue and tried to put down there, keep it off my bone.
And so he did go in, Your Honor. He had it adjusted because of the discomfort he was having. So they have subsequently loosened it for him. They did
go into what day?
So
it had to be I went on the 10th, so probably the 14th or the 16th. And that's when I asked the officer over
At what time did you do that?
I went over there. That's when I paid. I think I paid like 20 something. Yeah, $20. That's when one officer, he took it off my right foot and put it on my left. And I told him, I explained to him, I told him, I said, yeah, it was on my bone. And I took some tissue and put down the triangle because it was swollen. He took it off and he put some of that thing on there and, charged it back up. And then prior to that—
Does he want a hearing on this? Because I'm not believing anything he's telling me.
The defendant launches into a detailed explanation about the ankle monitor being too tight, causing bruising, and forcing him to pad it with tissue. From an outside perspective, this sounds less like a defense and more like damage control. The judge's tone signals disbelief, and the audience can feel the credibility slipping as the story grows longer and more complicated.
Want a hearing on the fact that you— Yes, Your Honor. My client would be asking for a hearing. He's saying he's not used alcohol. The only thing he has done is use some things that he has to use for his job, which he can bring in to show the court. So yes, he's asking for a hearing.
What kinds of chemicals is he talking about?
I mean, I use soap, pine soap, stuff to clean the toilet with. I mean, but I haven't drunk nothing. I even told the man over there that I sign my own self up at the church every Thursday at 7 o'clock to go to AA. So I haven't drunk nothing.
It doesn't even make any sense.
Yeah.
Your Honor, can he take an ETG test?
Well, at some point he might be able to, but right now, I'm a bit concerned with what he's telling me, that there's somehow or another a chemical that's doing that. And if that's the case, we would have readings all over the place because it would work more than just one day, right?
Here the judge presses hard on the logic of the explanation. The idea that workplace chemicals alone caused alcohol detection doesn't sit right, and the court openly questions it. This segment is crucial because it shows judicial reasoning in real time, dismantling an excuse not with emotion, but with common sense and experience.
And Your Honor, I don't have what the readings are. I know that what this report is saying is that on November 16th and on November 14th, were those days?
Yeah.
Okay, so he can tell you that he was at work on those days. None of these other days has he tested positive for anything on because he's not doing anything.
And those are two days
That they're a tamper.
So he's going to acknowledge he put something in between that and his skin because of the
And I
discomfort.
told them that.
He did admit that.
Yeah.
He just was doing it to put a cushion though because it was digging into his skin. And again, they have and there was a bruise, which is why they moved it from the one leg to the other leg. And so it has been adjusted. So he's not in quite the discomfort that he was in.
Why was he talking about an alcohol reading?
I'm sorry, why was he telling you?
Why was he telling them about an alcohol reading?
No, he did not. Apparently they told him that there was alcohol detected, and he said the only thing he can think of, it's the chemicals that he's working with because he's not been drinking.
And I bathed with a native soap. I mean, the lady that put it on, she told me, go on Amazon and get, order something with no soap.
No alcohol.
And no alcohol. And the native, it don't have alcohol in it. And that's all I use. Besides the toothpaste that I run on the 10th of November out home. That's what I use to brush my teeth with. Now that got alcohol in it. I got that at home. That's what I use. And like I said,
well, when I'm looking closely, I don't see an alcohol reading.
And I was going to say, Your Honor, I can't see any of.
Which is why I'm trying to figure out why were they discussing and why was he stating that the alcohol reading came from chemicals?
He is telling them that because he's saying, I didn't drink. The only thing I can think is because of the job that I do. So when they asked him about it, he's like, I haven't been drinking. Only thing I can possibly think is because of the chemicals I'm around at my job.
Your Honor, I agree that there's no alcohol reading, but the violation.
The prosecution steps in to clarify the technical difference between alcohol consumption and alcohol detection during a verified tamper event. This is where the case sharpens. Even without a numeric reading, the combination of tampering and detection becomes a serious issue. From a third-party view, this is the point where the defense narrative starts to collapse under scrutiny.
Describes that on both of the separate tamper events that alcohol was detected.
Correct.
Which would
during the tamper.
Which would work.
If you look at the bottom first page, the last bullet point
First page.
doesn't give a reading, but it indicates that alcohol detected during the tamper.
That's normally they distinguish between a consumption event and the detection of alcohol, correct? Like, we can't tell just based off of this, but when you combine the detection of alcohol with the verified tampers.
Yeah.
And again, Your Honor, it would make sense then, because if he does have something on his hand, but he's trying to adjust the ankle thing, it would detect because of whatever's on his hand.
Now my wife dropped me off. Now I did get me a Wendy's burger, and I did use the hand sanitizer in the car to wipe out my hand. So I mean, no.
So on two separate occasions this happens? Really?
No, when I went to pay.
You're okay.
No,
You're okay. Your Honor, my client, he is working on his drinking issue. Yes. He is saying that during this time frame, the only time he has ever adjusted this was because of the pain. Subsequently, he's gone and gotten that fixed. It's my understanding that there's been nothing since he's gotten it fixed.
The defendant adds more layers: hand sanitizer, toothpaste, fast food, and AA meetings, trying to explain away the detection. Instead of helping, it muddies the waters. Watching this unfold, it's clear the court is hearing excuses, not evidence. The tension here comes from watching someone talk themselves deeper into trouble.
Because it's been addressed. And the only thing he can think of is that whatever chemical he has is on his hand when he was adjusting and trying to get some comfort or some relief from the issue is what was detected.
I explained to them, I used a tissue and I put some, it was bruised over here, and I put some Vaseline on there. I mean, if they got alcohol in it, I mean, I don't know, but I haven't had a drink. I sign myself up at my job every Thursday night from 7 to 9 AA. No. And the guy over there, the last one on the 16th, he told me I can use any kind of soap. So he's telling me this, then the other one tell me no. So then the other lady tell me something
But
else.
what did I tell you?
Yeah, I
Okay.
mean, yeah.
Anything else?
No, Your Honor, just,
I'll give him a hearing on the second half of the violation. He admits to tampering, but as to the alcohol detection on it, I'll set that for November 25th, 2025 at 3 p.m. I'll adjourn his probable cause hearing to that date. That's 5 days out from now. But at this time, defendant's bond is both defendants.
This is the ruling moment. The judge cuts through the noise, acknowledges the admitted tampering, and grants a hearing specifically on the alcohol detection issue. A date is set, and the defendant is formally bound over. From an observer standpoint, this is the clean transition from argument to consequence.
thank you.
My name is Joshua William Mora. I'm representing myself in this case.
So you don't want to be represented by an attorney?
No.
All right. Well, I would say there come some perils with you representing yourself. You understand that, sir?
No. I know
You
the
don't
mission.
understand?
I'm a jailhouse lawyer. I know what I'm doing. You are working.
I'm sorry?
You are being paid by Adolph Mack to fry me. This is conspiracy for murder. Your wife, Delphia Simpson, came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati?
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that. You're invited
Thank
to
you,
do so.
Judge Simpson.
What do you want to do with your case today?
Ellen Mora, Adolph Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay, but I've got to do something with your case. What do you want me to do?
I would like to sue, and what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for
If
10 times the amount of what was stolen from me. They stole $666.8 million from me. They then turned it into $5.5 trillion and then put a hit out on me. I legally can sue for 10 times that amount, which would be $550 trillion. And I can criminally prosecute to the
I'm with you.
Which is
I'm
my
with you.
right.
I did the math too. Listen, here's the thing.
Mhm.
I have to advise you.
The atmosphere shifts dramatically as a new defendant appears and immediately rejects legal representation. What follows is a spiral into conspiracy claims involving murder plots, secret organizations, and powerful figures. This segment marks the beginning of a full sovereign-style meltdown, where the court is forced to balance patience with control.
Because if you are going to represent yourself, what you're here on, okay?
I'm doing it over Zoom.
So you're here on a complaint that alleges that on October 15, 2025 on South Main Street
the Pentagon's
in the
using
city of
prisons
Ann
to make
Arbor,
the
Washington
Zoom,
County,
mess up.
that you failed to stop at the scene of an accident regarding resulting in serious impairment or death. Do you understand that charge?
$1 trillion.
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
Which is actually 10 times the amount because I can sue because it's conspiracy to murder, and sovereign law would make it 100 times the amount. But since it is conspiracy to murder, sovereign law
I'm with
does
you.
not
I
exist.
got you. I just have to let you know what you're charged with.
I can sue for
There's
1,000
also
times the
count
amount.
2 on the complaint that alleges that on that same date and at that same time, that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes.
Okay. So there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of that you abide by the rules of evidence and the rules of procedure. You understand that?
Yes, Senator Simpson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel.
No, I do
all
not
you
want
have to
any
do is
counsel, and I
just
want a bench
listen-
trial,
listen
not a
to what
jury
I'm
trial.
saying.
Because a bench
And
trial
then
is
if at
based
any point you
on
do,
objective evidence.
if
A
at
bench
any
trial
point
is
you do
objective
want counsel, you just have to let the court know, and the court will make sure that you have counsel.
No,
You
I do not
understand
want
that?
counsel.
Okay, so what do you want me to do with your case today?
I
now
would like
that
to
I've
do a
gotten through
bench
that
trial
part.
because a bench trial is on subjective
bench
evidence,
trial?
and a jury
Well,
trial
that's
can
not
be
gonna happen.
bribed. And they're trying to
Okay,
bribe the jury.
you can go to
So
circuit
I
court and
want
have a
to
bench trial.
prosecute with sovereign law, and it's conspiracy to murder, and Donald Trump and Elon Musk are involved, and I can sue for 1,000 times the amount, and sovereignty
Your Honor,
does
if I
not
can
exist
if I
because the
can
amount of money that
I
they
don't know,
put
I've not been
out
very
on
good at
me,
it, but
and Donald Trump and Elon Musk and Adolf
so-
Mack and Doug Minkoff and Jeffrey Peake and Ellen Wara all have estates that and residencies in states that do apply the death penalty. I would like to get
Okay, I'm with you. I got you. Let me hear from somebody else real quick.